Hello, my name is Len. I'm with Targeted Justice. I'm a board member of Targeted Justice. And with me today, our general counsel, Anna Toledo. And we have breaking news for you. Good morning, Anna.
Good morning, Len. So glad to be here. Yeah, we do have breaking news, and hopefully that we are going to be changing the course of history with this historic filing that we made yesterday.
Okay, so we indeed filed a certiorari, a petition for certiorari to the Supreme Court. For our general viewers, foreign listeners, foreign viewers, let's just give a little bit of a civics background. So we wrote a petition to the Supreme Court of the United States. Is that a branch of our government, and how many branches are there?
There's three branches. There's the legislative, there's the judicial, and the executive. And so this is the highest court of the land, and they have the last word on anything that has to do with the Constitution and federal laws, which is what we're invoking. So, and particularly if you are suing federal officials, that is the last court that has to interpret anything having to do with federal officials and employees.
Right.
So the petition for certiorari is not like an appeal as of right, where the court has an obligation to see it. This is a discretionary writ, and what the court must see in order to issue it is that the questions that you present have national importance. And so, they grant very little percentage of the petitions that are filed with the court. But it is my hope and my conviction that we set forth, sufficient, as we will discuss, sufficient grounds to move the court to issue this writ of certiorari.
Correct. Yeah. So thank you. So that's what we did. The Targeted Justice filed a writ or petition of certiorari, and you explained what it is, to the judicial branch, to the highest level of the judicial branch. And what is the reason why did we do this? What moved us to do this?
Okay, so we had, for those that don't know, the district court dismissed the lawsuit that we filed, saying that the placement of innocent people, non-terrorist, on a terrorist database was illegal and an abuse of executive power. So the district court dismissed, saying it was fantastical because they chose to focus on the allegations of what follows being placed on the list. That you first, after getting on the list, this is what follows: the stalking, the surveillance, the directed energy weapons. And they just chose to focus on Voice to Skull as if it was fantastical and frivolous regarding, and this is our most important argument, and it is that a district court has to, at pleadings level, when you file your complaint and the answer to the complaint or the motion to dismiss, the court has to assume that what the plaintiff wrote in that complaint, if it is coherent and well pled, well, that it's true, because at this point it's not a matter of credibility, right? So the court did not want to grant credibility to, for example, one of the plaintiffs stating how a deputy sheriff told him, we were told that a terrorist lived here, when he was lying on the floor. That's one of the points that we bring up that we're going to talk about. So then the Court of Appeals confirmed that decision without going into the Court of Appeals has even a higher burden. The Court of Appeals had to say, okay, I am assuming the complaint is true. Let's see if there's really no subject matter jurisdiction because it's fantastical. You know, it's outrageously frivolous. And the Court of Appeals confirmed. So we went to the Supreme Court because the decision in FICRE, which is Federal Bureau of Investigation versus FICRE, that he had prevailed in the Ninth Circuit, it is our position that the court's decision in that case supports our petition for certiorari in as much as it allows a plaintiff to challenge their placement without reasonable suspicion on the TSDB.
Thank you for this answer, Anna. If I were to answer this question, I would say, why did the targeted justice do this? Is because thousands, hundreds of thousands, and millions worldwide of targeted individuals suffer from being a part of this covert program. So ultimately, the importance of this, of what we're doing, is extremely valuable and should be valuable to all TIs everywhere. And I can't emphasize it strong enough that even though the case is filed on behalf of 18 plaintiffs, it has consequences for the entire TI community, for all those people who are listed knowingly or unknowingly, who suffer every day. And that's the importance. We want to free targeted individuals everywhere.
Let me add to that in all judicial cases, in order to be able to proceed, you need to have what is called injury in fact. You need to have people that have injuries that are redressable. Okay, that's why we needed to have plaintiffs and plaintiffs that could establish, for example, one of our plaintiffs, in 2004, she started hearing the V2K. I mean, it's just like you are the first civilian diagnosed with Havana syndrome. The only thing that causes Havana syndrome we know are these weapons. So people have to appreciate that one of the things that we ask for and that we are insisting is on the elimination of handling codes 3 and 4 from the TSDB. And that is something that it's going to impact everybody. So that because we are alleging and arguing that those are illegal subcategories, because the Homeland Security Presidential Directive did not contemplate for non-terrorists to be on a terrorist database. Now, it will impact everybody, and everybody should just understand that it's not about these plaintiffs, it's about everybody, like you said.
All right, let's start the presentation and let's get into the weeds, because everybody wants to know what has happened, what we filed, what it contains, but you also must. It's just that it's not that we're just giving you this information. If you're a targeted individual or somebody close to a targeted individual, or just somebody who is who cares about retaining constitutional rights, you must know the content of this document. So let's get to it. So like we said, in the Supreme Court of the United States, targeted justice filed a petition for a writ certiorari. I think we all need to understand that the most important part of this document will be the reasons why SCOTUS, Supreme Court, has to take this case, because it has nationwide implications. It doesn't just affect the 18 plaintiffs. It doesn't just affect all the hundreds of thousands of US TIs. It also affects everybody, because they can be part of this program unknowingly. And that's the scariest part. I want you to take a mental photograph and take a breath and acknowledge this moment in history. So this is the time, this is the cover page of this document that we filed with the Supreme Court. So this is for the first time in history, the targeted individuals knocked on the SCOTUS door, knocked on the door of the Supreme Court. And Anna, what a monumental achievement. And viewers and listeners, just imagine how much work and what kind of financial burden it is to be on that level of jurisprudence. So I will ask for your support at the end, but I want to just acknowledge this moment. This is a historic moment. Take a mental photograph.
I want to add to that, Len, that I think that, in my personal belief is that there is the chronological time, and then there's the time of God, the chronos and the kairos, which is the perfect timing of God most of the time. And everything has been timed so perfectly. Like I mentioned to you earlier, the FICRA case was decided 11 days after the Court of Appeals confirmed the district court's decision. This is not coincidence. It is the perfect timing. And I have to say, we did file yesterday, but the Supreme Court has to review the physical document when it gets there, because it's filed by a company. They send it by mail, and then they have to confirm and corroborate everything is perfect, and that's when they docket it. So for those of you that might want to go and check it out and say, oh, it's not filed, I don't see it. No, because before the court dockets it, they have to receive the physical document that it's sent by regular, by first class mail, and then they have to verify it. So please bear that in mind before anybody goes around saying, no, that's not true. They didn't file it. Okay.
All right. And we'll make sure to share that link once it's officially on the SCOTUS webpage. We will make sure that it's shared with everybody. I want to acknowledge that this document is 234, I think, pages long. So we're only reviewing the first 46 pages, because the rest is the attachments of the laws, the administrative acts, the legal cases that we're bringing to the attention of the judges. And please correct me if I'm wrong. You told me that you still didn't have a full access to all the legal documents that you wanted, that you were prevented from doing this.
Well, what I was prevented from, and this is, targeted individuals know what kind of hacking and interference we go through. So, my legal research, Lexis, I couldn't access it from my router, so I would have to come to the neighbor's house and use it in their computer. And for a person that is in the creative process, you cannot imagine how difficult that is, that you cannot, in that very moment that you're writing something, go to the website. And that's one of the things. So I did not have complete, and even to my emails and the Lexis. So it was a very painful process, to say, because it was not like any normal attorney can carry it out. I did include, I have to say, the reason we included the complaint as an attachment, which is normally not included, but in this case we did, is because both the district court and the Court of Appeals decision it is our position, they don't reflect the actual contents of the very detailed complaint. And that's why we had to include it, so it is important, because this was dismissed at a pleading stage. So it's important for the court to see if it really was fantastical and frivolous, the lawsuit that was thrown out.
Thank you, Anna. So the document opens with a question presented. This is a question to the Supreme Court of the United States. And it's very interesting that you build on the most recent decision of the Supreme Court concerning mishandling of TSDB. So you're asking whether this court decision, the FICRA case, warrants reversal of the Court of Appeals decision affirming the district court dismissal with prejudice. This is the essence of our question to the SCOTUS. Reverse these decisions so we can have our day in court. Is that a correct interpretation?
Exactly, because what the Supreme Court did, the Supreme Court didn't say, yeah, FICRA has a due process right. No, that was the Ninth Circuit that said it. The Ninth Circuit Court of Appeals, that is where FICRA's case was because it's from Oregon, said, no. He has a right to pursue why he was put on that list without reasonable suspicion. And he was put on the no-fly list. That's why he found out about it, right? But the Supreme Court in Federal Bureau of Investigation versus FICRA affirmed the decision by the Ninth Circuit by saying, no, the case is not moot. It can continue. So by ratifying what the Ninth Circuit said, it is our position that if you ratified what the Ninth Circuit said, we want the Supreme Court to grant these plaintiffs the same right to challenge their due process, on due process grounds, why they were placed on a terrorist database without reasonable suspicion.
And I want to remind everybody that the Supreme Court decision in FBI v. FICRA was 9-0, so it was unanimous, and that's really important. That it sounds like in this arena, the Supreme Court has a unified voice. It doesn't matter if you are a Democrat or Republican or independent. These constitutional rights are basic foundation of our freedom. And if you're interested in preserving it, you have to reverse these decisions.
The oral argument in FICRA was very revealing because Judge Kagan and Judge Sotomayor, who are from the liberal, side of the bench, they were so offended by the fact that people, it's like, how can you say that, oh, just with the information you have, you're not going to put him again, but that doesn't guarantee this, and it was a really interesting exchange. So if I urge people to listen to it, it's available online in the SCOTUS page, the oral argument, and it'll it's very revealing because it's like you say, they are all unified that it is wrong. It is wrong if a person does not meet a criteria, they should not be on a terrorist list, and that's exactly what we're asking for.
We're continuing with reviewing writ of certiorari and going to the introductory pages. You describe parties to the proceedings, their plaintiffs, their petitioners, that's us, Target Justice, and 18 plaintiffs, including 3 minors. And the respondents, there are 5 individual respondents, including Mary Garland and including Charles Cable, and there's a interesting reference to that name. And we sue in 2 agencies, the FBI and the Homeland Security. So please tell me the history of this little footnote that you have in the document. What is it about?
Well, as you know, Mr. Cable, as soon as we filed a lawsuit, he announced his retirement from the FBI, and he retired effective January 31st, 2023. What is really interesting is 2 things. Number one, the defendants had an obligation to the court to report it, inform it, and substitute him, and they never did, neither at the district court level nor at a court of appeals level. I asked the Court of Appeals and they denied my request that he be substituted. And then most important, and this is that, you know, as you know, I did a roster for for checking the names in the TSDB if and when the court grants us that chance. And it turns out that most people, Mr. Cable started working as director of the TSDB in March of 2016. And our numbers reflect that around 60 something percent of the TIs that answered my form had been placed on the TI, you know, had become a TI from 2016 on. So I see there are a huge correlation between the inordinate amount of TIs that have been placed on this program since 2016 and Mr. Cable's retirement as soon as this lawsuit was filed.
So he's been in charge of this database for 7 years.
He was from March 2016 until January of 2017.
Yeah. January 2023.
2023. Sorry about that. Yeah. That just proves how very difficult it is for both you and me. We're getting, blanked a lot, and it's very distracting sometimes. But yeah, that's January 31st, 2023. You know that in the federal government, you have to give at least a 2-week notice, advance notice you're leaving, right? So we filed on January 11th, and by the 31st, he had retired.
Let's go to the legal background. There's a statement of the case, and it has a few subparts. The first part is a legal background of what's happening. So we're talking about terrorist screening database. Its origin is a Homeland Security Presidential Directive. The HSPD 6. You will see a reference to it throughout the presentation, and it was issued in 2003. And we point out that this presidential directive only authorizes the inclusion of the identities of individuals when there is a reasonable suspicion that he or she is a known or suspected terrorist. Known and suspected terrorists are listed in the TSDB handling codes 1 and 2 subcategories. So imagine TSDB, there are a total of 4 categories. The first 2, 1 and 2, the handling codes 1 and 2, they jointly comprise what is commonly referred to as the terrorist watch list, because it does contain known and suspected terrorism that satisfy reasonable suspicion. However, we learned that the terrorist watch list only occupies 0.29% of TSDB.
Yeah, that is an Office of Inspector General report. Yes. That states that the actual known and suspected, and please bear in mind, Ficre was in the no-fly list, and he alleges that he was placed there without reasonable suspicion. So when we say known and suspected terrorists, we have to take it with a grain of salt, because as Ficre is alleging in his case, the FBI put him in there because he refused to be an informant. And as a retaliation, he alleges they put him there without reasonable suspicion. But yeah, the actual known and suspected terrorist, or alleged actual known and suspected terrorists, only form 0.29% percentage as per an audit report that was carried out of the Terrorist Screening Center by the Office of Inspector General of the United States Department of Justice.
That is correct. Thank you for reminding me. Going back to the entire TSDB, we said there's category 1 and 2. And then category 1 and 2 only comprise a little sliver of that, of the pie of TSDB. It's 0.29, less than 1/3%. So there are 2 little known subcategories of TSDB that are not authorized by the presidential directives, known as handling code 3 and 4, that together comprise 97% of the names in the TSDB. These subcategories contain the identities of individuals whom FBI admits do not represent the terrorist threat and do not meet the reasonable suspicious terrorist criteria, and children as young as 3 years old appear on these two categories.
This, I took it, you see, all those references are references to the lawsuit, because this, you cannot say this is fantastical because this is uncontroverted. See, this comes from official document reports that state this. And if it's an uncontroverted government admission, you cannot say it's fantastical. So that's why I put it there, because I know that targeted individuals know this, and if you don't, you should know this back and forth. Just, you can recite it in your sleep. But this is the crux of the matter, that you have a terrorist list, and 97% of that list is made of people that do not meet the reasonable criteria, terrorist criteria. So let that sink in. Why do you have 97% of people on a list for alleged known and suspected terrorists that don't meet the criteria? It just doesn't make sense under any conceivable theory, period.
Correct. And neither the district court nor the Court of Appeals reviewed that, because it was dismissed without looking at the facts. It was dismissed on the lack of subject matter. So without looking into this fact, it was dismissed. It didn't allow us to have our day in court, like I said before. Let's move on. Continuation of the legal background. Statements under penalty of perjury signed by Mr. Samuel Robinson in his capacity of Associate Deputy Director for Operation of the TSC. This is the gentleman who was in charge of the TSC Terrorist Screening Center between after Charles Cable left and before Mike Glasheen was assigned. So he is a sort of a temporary, he's a placeholder for the director of Terrorist Screening Center that operates the TSDB. And he's the one who gives this specific statement. Samuel Robinson talks about these categories 3 and 4. These individuals are not considered known or suspected terrorists and are not screened as such. As a result, any U.S. person who is in the TSDS, this is incorrect because we know it's not a data set, it's database, and the courts acknowledge that. Pursuant to an exception to the reasonable suspicion standard. So he talks about an exception. Something that is not supposed to be in the database. In his own words, he said, oh, no, there are people there, but they're not placed there by, according to the directive. They are placed there as an exception. And therefore, they would not genuinely be subject to heightened aviation security screening at the airports. In order to maintain the effectiveness of these special screening functions, details regarding the method by which individuals are identified for watch listing exceptions, there you go, must not be disclosed and are properly categorized as law enforcement sensitive. We also called it a secret criteria. And it's a clear violation of the Presidential Directive 6 and a violation of Administrative Procedure Act. Blatant violation. How did we come to this end?
Let me remind you that Mr. Robinson was promoted to that position the day before, and this I noticed because when he did his sworn statement, he put that I am in this position since this date. So it was the day before he gave that statement that they upgraded him to that position. Okay. It's like, okay, we're going to give you this job, but You have to sign this. And one of the things that it just strikes me is how, the FBI doesn't realize that they are admitting to violating the law under penalty of perjury, because you cannot have secret criteria, let alone protected by law enforcement privilege, because law enforcement privilege is for when you have actual criminal investigations. You cannot use law enforcement privilege to cover up illegal agency action. You cannot do that. It's prohibited by an executive order signed. I think it's signed by Obama. I quoted in the lawsuit. You cannot use these privileges or whether it be confidential or law enforcement. So you cannot use these privileges or classified to cover up agency unlawful behavior, like placing people that don't meet the reasonable suspicion criteria on a terrorist database.
And yet they've been doing it now for over 20 years. And, and nobody has raised the red flag.
Let me tell you something. The thing is, and that's why people need to appreciate that Richard Lighthouse, his testimony is so valuable, because it is his testimony about being on the floor of his house, suffering from a blood clot in his lung, and the sheriff saying, no, we were told that a terrorist lived here and we have to secure the area. And it took them almost an hour before they let the ambulance in. This is injury in fact. This and then the district court said, oh, well, he cannot allege he's not there because he hasn't seen the list. Well, in FICRE, the Ninth Circuit said that the FBI doesn't tell anyone that they're on the list, except if you're in the no-fly list, because they don't let you fly. But the rest of the people are not told. They don't tell them. So how is anybody ever supposed to get, and we did a Privacy Act a request to confirm that. So it's just Richard and Karen Stewart's testimony about how they found out they were on the list, and that's how they connected the dots between the atrocities happening in their lives and these secret categories. Nobody, this is a first case, Len. This is a first case, even though there have been hundreds of dismissed TI cases in federal courts against different agencies, whether it be FBI, CIA, DHS. Tons of agencies have been sued. Hundreds of cases I have seen dismissed. But this is the first case ever that alleges the direct correlation between being unlawfully placed on a terrorist database without reasonable suspicion and the stalking, the harassment, and everything that comes with it. This is the first case ever that does that.
I agree. And that's another significance of this case. We're continuing with the legal backgrounds. So after FBI illegally puts these people in these subcategories, it distributes this information, this private sensitive information, through the National Crime Information Center, as if they are convicted in crime. But because that's what this NCIC is for. It's a national crime information. You have to commit a crime. So, but these handling categories 3 and 4, they did not commit a crime and they didn't meet reasonable suspicions. Yet their private sensitive information and the fact that they are on the suspected terrorist list is distributed to 18,000 law enforcement agencies, more than 532 corporations, and 1,440 organizations in 60 countries. I wonder what these 1,440 organizations are. Do you have any idea?
Yeah. Well, let me make a disclaimer. These are 2019 numbers. These numbers have gone up, but these are the numbers we obtained from the discovery in El Haiti versus Cable case, which was originally El Hedy versus Pajota, and the Judge Trenga had declared unconstitutional the TSDB, and then the Fourth Circuit reversed. So I didn't make these numbers up. These numbers came from the FBI, produced to the plaintiffs in that case. Now, these 440 organizations, well, you have organizations that are not necessarily for profit, okay? Or for example, you have universities. You have, I don't know, like credit agencies, are under that. I don't know if they're under there or under the corporations, but certainly in the biggest corporations, you have, from Amazon to Microsoft, to Airbnb, to VRBO, to CVS, to Walgreens, all those huge corporations that are comprised in there. Kroger's, Trader Joe's, all these huge corporations. But the organizations, I believe, it's more like universities and entities that, even though they're huge, they are not necessarily under the for-profit label. That's what I think. We haven't done discovery, so we don't know. I just got this from the discovery in that case.
Yeah, I understand.
And let me tell you something. Richard Lighthouse did a FOIA request asking, and I think this should be public information, asking which are these corporations and organizations. Don't think we haven't done the work. He did the work, and the FBI replied, we're not going to tell you that it's private information. That is another case that we have to pursue eventually. But for now, I just tell you that Targeted Justice has been doing its legwork, trying to find out who these organizations or corporations are.
Understand. Well, disseminating this information, telling these organizations, corporations, and law enforcement agencies and everybody that these people are listed in the suspected terrorist database, that's nothing but a government label. This is government defamation. Wouldn't you agree?
Absolutely. That's exactly what one of the main contentions is, that this label follows people to everywhere they go and affects every aspect of their life. You and I know of a very close collaborator to Targeted Justice that she ordered a pair of beds, and the online store refused to sell her beds because clearly they receive the TSDB. They are on the distribution list. She wasn't buying weapons. Right. She was buying two beds.
So hypothetically, they wouldn't do business with her because because the company doesn't want to do business with suspected terrorists.
Correct. That's correct.
Yeah.
That is correct.
And so we know from number of cases and from our experience and from everything that you researched that TSDB listing affects major aspects in an individual's life. However, Congress has failed to enact the TSDB into law in the 20 plus years of its existence. That is important, and I think it's even more important now after dismantling the so-called Chevron doctrine.
That's exactly it, and it's even because here's the thing, that's called anybody can just Google it, major questions doctrines. In the Kovac v. Ray case, which is currently pending, even though the oral argument was held on March, it has not been adjudicated by the Fifth Circuit. And in that case, it's so beautiful. I tell you, it's Kairos. It's so perfect because in that case, the district court, which is the Northern District of Texas, held that in fact, being on the TSDB does affect major aspects of your life. And the argument before the Court of Appeals is, well, you have to declare the TSDB illegal because it violates the separation of powers, because if something affects major aspects of a person's life, it has to be an act of Congress. It cannot come from an executive order. And that's a controversy currently pending in Kovac v. Ray on the Fifth Circuit. So yeah, this, but we are alleging it's even beyond the people that are supposedly known and suspected terrorists. It affects the life of people that don't meet reasonable suspicion and are affected by illegal surveillance, illegal harassment, and everything that comes along with it. Remember, and this is what people need to know, and if I could just tell everybody, is unless there's probable cause against you, they're not supposed to be doing surveillance on you. I don't, if you're an American citizen, if you are a US citizen, you're not supposed to be undergoing surveillance. And so that's basically what we're saying. We're saying it really does affect our case. It's not about major questions. That's Kovac v. Ray, but I put it in there because it's the truth. The Congress, in 20 years since the TSDB has been operating, why hasn't Congress authorized a law approving it? It escapes me.
Right. And because of that, the only executive order that we have regarding the handling and maintaining and operating TSDB is the Presidential Executive Order 6. Congress
did authorize, and this we know, the redress mechanism for people that are not allowed to fly, and it's against TSA, and it is telling TSA, yeah, you can not let people on this list not get on board, and also provide a redress mechanism. But that's exclusively limited to that, to providing a redress mechanism. Remember, and that's one of the things we're saying, targeted individuals in handling codes 3 and 4. I don't use the word targeted individuals anywhere in the document, but the people in handling code 3 and 4 have no mechanism of getting out because they never find out. They never get their travel is never interrupted in any way because they're not supposed to find out ever that they're on the list.
So in other words, we can call them listed individuals. It's a little bit mouthful, but that's the essence of our case. We're listed illegally, and we want to be removed. And we want to close these illegal subcategories in which we are listed. So it's a case for everybody who is listed in these categories illegally, because they're not supposed to exist.
Exactly.
It's an invention of the FBI. It is nothing but an invention of the FBI. And we let them do it for 21 years.
Yes.
All right. Finally, we're getting to the petitioner's complaint. So like we said before, 18 plaintiffs, 17 of them are US citizens and 1 legal resident. 2 of the petitioners, whose names you already mentioned, provided specific factual allegations about the circumstances under which they discovered that their names appeared on TSDB's handling codes 3 and 4. Law enforcement officials entering into contact with an individual in these subcategories are advised against telling the person that they're on the list. And yet it happened. It happened with at least 2 of our plaintiffs. Why do you think that disclosure happened? When I think about case of Richard Lighthouse, I'm thinking, okay, this is Texas. There's a sheriff. The sheriff didn't read all the regulations, and he kind of blurted out that, oh, well, we can't, we have to secure the premises because before allowing him to receive urgent medical care, because there's a terrorist lives here, and there's only him and his 87-year-old mother. So in my sort of imagination, it's the old-timer sheriff from Texas to maybe is looking toward his retirement more than looking forward to reading regulations.
Well, also remember one thing. Richard's incident was in 2012 when this was it was still hush hush, I think, program per se. Like now they're very, I think many of them are very alerted and many of them participate in it. So I don't, I don't know that there was the awareness that 12 years later we have. That's one thing. And yeah, certainly he did not read because those instructions are provided by the FBI to a different to the states law enforcement. And the reason I know that is because that was part of the discovery in the El Haiti case that I read over 900 pages that were produced in the Court of Appeals case, okay, as part of the appendix to the Courts of Appeals. So I didn't make this up. It's a document generated by the government that contains that instruction. If the person is in handling codes 3 and 4, you are not to tell them that they are on the list, and it's even worse because it says, and by the way, look around to see if you can get any evidence of something, and it's in one of the documents that was submitted. So yeah.
So in summary, FBI openly acknowledges that these individuals in handling subcategories 3 and 4 have no ties to terrorism. So petitioners have a right to pursue their due process claims, to challenge their nomination and obtain an order prohibiting respondents from perpetuating their unlawful practice of listing non-terrorists on the terrorist list.
Crucial to this due process situation is the fact that early on in the case, plaintiffs asked for the FBI to certify to the court their TSDB status, and they fought it tooth and nail. And for 3 months, the court did not adjudicate it until it dismissed the lawsuit and said, oh, we're dismissing it as moot. And that is part of the process because discovery is an essential part of the procedural due process, because no litigant comes to court with all their evidence in a suit case. And that's exactly what the district court said. Oh, no, they have to have that list and have seen it. No, this is a sensitive document. It's not, they're not allowed, they're not going to be allowed to see it unless, somebody leaks it to the world. But the point is that due process perspective is not only that they're not told they're being put on the list, they are not given an opportunity to controvert it. They are being placed without reasonable suspicion. Remember, there is something called that, I don't know what happened to the presumption of innocence of people in this country. And then the placement is for life. And we put it in there, Inspector General reports saying how there are outdated nominations without reasonable, without grounds, or terrorist grounds to put people in there, and outdated nominations. So, even the other branch of government, the Department of Justice, which is within which the FBI is, which is within which the TSC is, up here is saying you're doing things wrong, but they didn't stop them. And that's what we're saying. The procedural due process violations are too many and are just causing a lot of harm.
Yes. Thank you for that. This is an important page. I even made a comment, my specific comment regarding that. Petitioners allege that they are placed on the TSDB's handling codes 3 and 4 despite not meeting reasonable suspicion criteria as a punishment for the legitimate exercise of First Amendment protected rights, including whistleblowers, political activists, and scientists opposed to government policy. And some of us still don't know why they're placed, like me. So as a result, petitioners and targeted justice members alleged to have been subjected to a largely secret covert program disguised under a shroud of plausible deniability that perpetrates stigmatic government action upon them. And we'll go into details what we mean by that. But the 18 petitioners in this case allege facts and damages that they have in common. And what they have in common are symptoms and situation that an average person would deem implausible. And that I want to send this message loud and clear. A lot of targeted individuals are considered, a little bit off, or they are talking about events that happened to them that an average person would say, it's likely just your imagination or something like that. It's implausible that, people would stalk you and defame you. This is your imagination. But this is exactly how this program is designed. So I'm saying this is a feature and not a bug.
Absolutely. And there's something about the plausibility is it's mathematically implausible that these people that come together have the same symptoms, the same, characteristics, events happen in their life. It's mathematically implausible to have this group of people with these same plausibly deniable events happening in their life. You'll mention it later, but our country has a nefarious history of these kinds of programs. And the Supreme Court is not, it is very well aware of it. So that's one of the things that, they cannot come with a story of, it's a conspiracy theory, because there is history a nefarious history in the United States that the intelligence agencies engage in this kind of unlawful behavior.
You're correct. There's a precedent of these programs, and the court cannot deny it. There's one more page on the petitioners about petitioners' complaint. These are specific things that happen to majority of TIs. They all tell the same story, that they experience harassment known as gang stalking or organized stalking, or overt harassment that includes the use of organized stalkers to carry out the vandalizing of personal property, surreptitious break-ins into domicile. So in other words, they break into your homes. Tampering with postal mail, computer, telephone, and electronic communications, also known as electronic interference, and spreading false and defamatory rumors about the individuals in the neighborhood and workplace to attain their virtual ostracizing from society. There's a historic precedent to that also. But what we claim is that in the United States, it's perpetrated, at least in part, by the Homeland Security-controlled national network of fusion centers. And where we got that evidence from, I think the majority came from the Brennan Committee assessment of fusion centers. Correct me if I'm wrong.
Yeah, the Brennan Center did a report on fusion centers that is devastating, but Targeted Justice has a lot of evidence prior to the Brennan Center's report about the coordination, and you can look at the contracts, the memorandum of understandings between DHS, because DHS controls the fusion centers, and the local police departments. And we have a lot of that information that establishes that connection of the national network of fusion centers.
Correct. And so as a result, petitioners, in this case, sought permanent injunction from keeping their names on the TSDB without reasonable suspicion. And also petitioners sought declaratory judgment confirming violations of due process rights. That's what we asked the district court to do.
Well, no, we asked for a lot of other things, but you have to take into consideration there's a $9,000 word limitation to what you can write, and you can only write about what's really important. And what's really important, the crux, the most important thing the targeted justice and those 18 plaintiffs asked for is, number one, remove me from that list. Number two, declare it illegal. So yeah, we did ask for more stuff, but that's the crux of the matter. That is what we're asking the Supreme Court. Please reverse this, because among other things, obviously, we have a right to do other things, but this is the most important thing, that that these plaintiffs are allowed to prove their case.
After we reviewed the petitioner's action, we will review the respondent's motion, respondent's answer, and they responded with a motion to dismiss. They said the allegations of the complaint were fanciful and fantastical. However, respondents did not controvert with any evidence or sworn statements the veracity of petitioner's well-pled factual allegations of the complaint. That was a surprise, but I think it was part of the strategy, not to address these questions, convince the judge that these are fantastical allegations and dismiss the case before looking at the merit of the case. And that's exactly what happened. So I think it's a strategy that was planned by the respondents. And when petitioners attempted to carry out limited discovery about TSDB status, respondent refused. But this discovery, this looking at TSDB, has been done in other cases. And that's what's really, there's a big incongruency between what happened in other cases about TSDB and what happened in our case about TSDB. And what's interesting that for 3 months and until the dismissal of the complaint, the district court did not issue an order to respondents instructing them to produce petitioners' TSDB status, despite of their prior cases. Is this a coincidence that the court was sitting on this petition for 3 months and didn't issue an order until just before dismissal?
Simultaneously, when the court dismissed, said, "Oh, and that the request is moot." But here's what I urge the Supreme Court to look at it is to, if the FBI had produced the TSDB status of all those 18 plaintiffs and none of them were on Handling Codes 3 and 4, guess what? There's an automatic dismissal for lack of standing because none of them are there. However, if they had produced it and it confirmed the allegations, the district court would not have been able to dismiss the case. And that's what we're telling the Supreme Court. It's unfortunate that it was dismissed as moot. Denied as moot.
I think it was a legal strategy by the respondents. And I'm afraid that the district court was sort of in cahoots with the executive branch, which is, or respondents, or this is highly illegal. And I'm just afraid that that's what happened.
Well, I don't have evidence of that. I am just putting to the procedural uncontroverted facts to the court, because the court will see them and say, well, perhaps a discovery request should not have been not acted upon during 3 months while those were pending. But that's for the court to look at it and give it the weight they want to give it.
All right. So we need to continue the story about respondents. And respondents argued that petitioners failed to plausibly allege that they were listed in the TSDB, even though they repeatedly did so throughout the complaint. Instead, respondent devised a legal gotcha proposal and suggested that some petitioners exhaust their administrative remedies regarding the Privacy Act's request on their TSDB status, and that is wrong. Please explain why it's wrong.
Well, for one, in the Fifth Circuit's precedent and even all the United States, you do not have to exhaust administrative remedies regarding the Privacy Act. It's not a legal mandate. It's not jurisdictional. Number two, it's an exercise in futility because, as I mentioned in FICRE, in FEI versus FICRE, the Ninth Circuit Court of Appeals, put it as a conclusion of fact that FBI doesn't tell anybody about their status on the TSDB. So it was, in my opinion, it was go and exhaust those remedies while the time to appeal this judgment elapses, and then these plaintiffs would have been left without a recourse, because if they didn't appeal, if these plaintiffs did what the Department of Justice suggested and not appealed and instead went to try to exhaust these futile administrative remedies, then the time would have elapsed and they would not have been able to seek review of the dismissal of the complaint. Did I make myself clear there?
Yes. And this is exactly what this last bullet point is about, that the district court adopted this suggestion and instructed petitioners to resend this request, to exhaust administrative remedies when we're not legally compelled to do that. And while we know that this is, and everybody knows that this is an exercise in futility. So this is completely in line what you put in the request. Then what happened? The district court dismissed the case. And it dismissed the case the day after defendants filed their motion to dismiss. The court entered memorandum and order adopting fantastical and bizarre characterization of the pleading, dismissing the complaint for lack of subject matter jurisdiction. Although the dismissal was not on the merits, the district court entered it with prejudice and didn't leave anything for the court to adjudicate. That is like a double whammy. It's not just dismissed, but dismissed with prejudice. And that means that all the plaintiffs, they cannot come back to any court with their pleadings because it was dismissed with prejudice. So it's like cuts our hands off. It just like we were not given a chance to have our day in court, and they removed our future chances to do so. And at the same time, the court did not enter a separate judgment. What's the significance of that, Anna?
Because the Court of Appeals decided that they were not going to review the appeal because it was not a final judgment, which we argued it was, because it disposed of all the matters against all the parties. That's number one. And then so the Court of Appeals affirmed it collaterally as a review of the motion for the denial of the motion for preliminary injunction. But there's a rule that says, a federal rule of appellate procedure that says that the judgment does not have to be in a separate document. The decision does not have to be in a separate document to be an appealable order. So that's what that means. We just put it in there. It's it's an important procedural issue, but we chose, I had to pick my battles. And so that's why I put it in there, but it's not the main contention. The main contention is that under FICRE, the Fifth Circuit decision warrants reversal.
Correct. That's in the question. That's that paragraph that we opened this presentation with. This is the main question of the petition. After district court dismissal, the petitioners appealed to the Court of Appeals in the Fifth Circuit Court of Appeals. And a 3-judge panel of the Fifth Circuit affirmed the district court dismissal with prejudice of the complaint on the subject matter jurisdictional grounds and ordered the exhaustion of administrative remedies. Both do not make any sense. The Court of Appeals also echoed the district court, concluding that petitioners could not allege being on the list they have never seen or otherwise confirmed. That is just a blatant slap on the face. We can send 100 requests and we will still receive the same response. So this is flagrantly inaccurate.
One of the comments I included somewhere is that the records of both the district court and the Court of Appeals reflect the kind of second-class citizenship that people on these two unauthorized categories of the TSDB undergo on a daily basis. It's there. It's very interesting that I guess you remember the story of the disappearing sentences. Well, when I wrote about this I remember I did it in the morning. I think it was Friday morning, and I incorporated this passage about the 3 months and the discovery, whatever. And when I got to where I was working and continued working, I had to rewrite them. For some reason, those passages about the limited discovery and the 3 months and the FICRE, how FICRE says that the people are not told that they're there. That took me like 2 hours to write, it had disappeared by the time I got to where I got. So it is a very important part of this that it's very, very important because it goes to the crux of the matter, which is these people are on this list and they have no means of finding out. And we have 2 people that got circumstantial evidence they're on this list, and the court had to believe their well-pled allegations because they were detailed and they were specific. So, yeah, that's what we're saying. The court had to believe these plaintiffs.
We're back. This is the most important part of the petition because this is the section in which you, Anna, are trying to reason with the Supreme Court judges why they have to take this case. First of all, the district court disregarded its obligation to take well-pled factual allegations of the complaint as true and view them in the light most favorable to the plaintiff. That's a violation of Rule 12b. And then likewise, the Court of Appeals did exactly the same. And there's an irreconcilable scenarios between the pleadings and the facts presented by the petitioners and courts' interpretations of those facts. Why did it happen? How come we are providing these facts and they interpreted in completely different way? How could that happen?
Well, I don't know, but what they did is that they focused on, as you very well know, voice to skull, and they just chose to focus on those things that for the average American are so atrocious that are very hard to believe. But the thing is, they went to part 2, skipping part 1, which is talking about the illegality and evaluating the illegality of having innocent people on a terrorist database. That we didn't say it. Office of Inspector General said it, that 97% of the people on that list do not meet the terrorist criteria. We didn't make that up. So they that's how it happened. They got blocked. The perception, I think, was focused on, their perception was focused on something so very, very truly atrocious. Who wants to believe that our government is doing that to its own people? No one wants to believe that.
But in doing so, they executed pick and choose strategy. Is that really? I'm not familiar with the rules, but they decided to pick only certain things and ignore the other ones. Why did that happen? Why
I don't know.
is that legal?
I don't know.
Is that procedurally correct?
I don't know, and that's exactly what we're asking the court. We're saying to the court, what is written on both the district court memorandum and order and the opinion does not correlate to what is written in the complaint. That's what we're saying. So please look at it. Please look at this, because they had to assume that these well-pled facts were correct, and there's no reference to them in the district court's decision, affirmed by the circuit court. We don't know. We will never know then. But what we're asking the court is just corroborate this and check that one thing does not match the other.
Right. The other reasons for granting petition would be a violation of due process rights. It's a fundamental constitutional right. So when an erroneous suspected terrorist label threatens a person's safety of life, in the case of petitioners, the concrete harm goes beyond the intangible but redressable reputational harm to clear irreparable harm that triggers a person's due process rights. I think I understand the meat of the argument. But the second argument, you said, Supreme Court, you just decided, made a decision in the Ficker case, and it's all about due process unanimously. So, and you said this is a violation of due process. So why isn't this a violation of due process? I can't think of a more fundamental. Well, freedom of speech is more, I think, is a more fundamental constitutional right than due process, but due process is highly important.
Well, they're all in the Bill of Rights, and the thing is that the label, as you remember, the decision in the case TransUnion versus Ramirez, where Judge Kavanaugh say, no, there are some intangible harms that are so atrocious, like being called a suspected terrorist, that they grant the person injury in fact. And so what I'm saying here is this is beyond the mere reputational harm, which is very bad for anyone that has, that for anyone, it's atrocious. This is that this person was denied medical care, urgent medical care, because he was erroneously labeled a suspected terrorist. It doesn't get worse than that.
It doesn't.
It doesn't.
All right. More reasons for granting the petition. The petition contains other considerations of national importance. Post 9/11 war on terror has become a war on Americans. Being listed on the TSDB forever changes the life of that person, converting him or her to a second-class citizens, whether they readily become aware of it or not. So anybody can be listed because the criteria is secret. You are not informed. You don't have due process rights. You're not presented with any accusations. It happens silently, and you don't have any redress, and you might not even be aware. That is one of the considerations of national importance.
What I hope the court, the judges, the justices, they ask themselves is, why would they put non-terrorists on a terrorist database? And that's when it'll click, because there's no other reason. You don't, like you say, you don't tell them that they're there. You don't tell them that you're putting them there. You don't let them get out. So the court has to ask itself, wait a minute, so why are they putting them there if it's not for an unlawful reason?
And the Presidential Directive 6 certainly does not authorize the inclusion in the TSDB of any person that did not meet terrorist criteria. Back to the due process. Fourth Amendment violations has implications of nationwide importance. Just tell any American, we're going to take your due process rights away. Like, that is totally unconstitutional, totally un-American. And this is all carried out covertly in abuse of delegated administrative authority, shielded under plausible deniability, using secret criteria and an open disregard to basic due process rights. What the lower courts deem fantastical are the same tactics used in documented illegal programs that intelligence agencies operated for decades without restraint, such as those documented and summarized in this legal case known as MK Ultra program. So prior to that court decision, prior to the court's recognition of the existence of these programs, anyone denouncing them were called conspiracy theory. And for decades, its victim passed away with no recourse. But now that we know that there is a precedent, the courts cannot say that it cannot happen again.
Yeah, there is a precedent, because here's the thing. It's not just FICRE that is going on. Courts act in the context, in the historic context they're living. And they have to, they are aware, for example, of that congressional report mislabeled as a threat. They are aware of the dozens of cases challenging the TSDB. There's also the COINTELPRO cases that didn't make it necessarily to the Supreme Court, but are very well documented, which is the FBI, because MK Ultra was CIA, but the FBI spying on people for their political beliefs, such as in the Socialist Party case. And I have, as I mentioned in the Puerto Rico, in the complaint, 74,000 people in Puerto Rico, their lives were obliterated by the FBI using illegal tactics just because they believed in independence. And that is documented in a legal case that went all the way to the Supreme Court. It was a class action lawsuit. So there is precedent of the nefarious, unlawful behavior by the intelligence agencies abusing citizens, and that's what we're asking the court. It's not fantastical when there is if there is precedent, documented precedent about behavior that is contrary to law.
I agree. Thank you for this explanation. This is a really important page to me. The illegal government stigmatization and discrimination against 97% of the individuals on the TSDB that have become second-class citizens make this case one of the utmost importance for the future of our nation. It was a flagrant error for the district court to dismiss it and for the Court of Appeals to affirm it. Beyond petitioners' claims, this case presents the imminent danger for every individual innocently basking under the perceived protection of the Constitution of the United States, unaware of the fact that these tactics could any day be unpredictably and permanently unleashed against them. That is, I highlighted because this is my favorite paragraph in the petition. People who are basking in the constitutional rights, and they think that they're still in place. Here's an example of deliberately taking the due process rights away.
And that is a question of national importance, because that's what the Supreme Court is there for, to protect people's constitutional rights from governmental abuse. And that just goes to the gist of the matter, because you and I know of so many people that have been, everybody has been unfairly placed on this list, but because it shouldn't even exist. But the fact that their rights at every level are violated, it's outrageous. It's just completely outrageous. And yeah, so I hope that the court is convinced that it's certiorari worthy. The case is certiorari worthy for them to review it and remand it to the Fifth Circuit.
And there is something else to it. The fact that we are becoming a police state. This is pretty much an example of this transformation that we've seen in history before. This is what destroyed the Weimar Republic. There was a country called GDR, German Democratic Republic, where 27% of the population had dossiers on them, and there were enormous amount of people working for the Stasi regime. That's a police state. This is a rule of the executive branch. So this is what we're warning about, that our country might be transforming. And I think it is transforming into the police state when these constitutional rights can be ignored by the executive branch. And it also has a whiff of this sort of pre-crime conversation. So how can we prevent mass shootings, terrorist attacks, anything? How can we control what people think? How can we know what they think if they're planning something? This is incompatible with the US Constitution, where people are investigated, they're given a notice of what law they crossed, and it's because of the Fourth Amendment.
The Fourth Amendment basically says, you cannot submit people and their property to unreasonable searches and seizure without probable cause, and that's an essential demand, that because just being placed on a terrorist database is also a violation of Fourth Amendment without being a terrorist, because you're not safe in your person. You know very well that these lists they put the neighbors against anybody on the list, telling them that they're criminals. And that's one of the aspects of the Fourth Amendment that we're mentioning here too. Too many constitutional amendments and protections are being violated by this operation.
And you conclude your petition by these statements that the curtailment of handling codes 3 and 4 second-class citizens is no longer a secret. It's in the government documents, so they cannot deny it, and it's no longer a secret. Senators know about it. For example, former Senator Trey Gowdy brought it to the public's attention when grilling a DHS official about the unrestricted placement of U.S. citizens on the TSDB. And you provided a portion of a transcript. Would you do the honor and read some of it?
Yeah, I'll try to do it as best, because
okay.
I urge people to go check it out. Just do the Googling of it. It was in 2015. And he goes, let me ask you this. What process is afforded a U.S. citizen, not someone who's overstayed a visa, not someone who's crossed the border without permission, but in the American system, what process is currently afforded an American citizen before they go on that list? And when I say process, I'm actually using half of a term, due process, which is a phrase, I love it, we find in the Constitution, that you cannot deprive people of certain things without due process. My question is, can you name an another constitutional right that we have that is chilled until you find out it's chilled, and then you have to petition the government to get it back. My question is, what process is afforded a United States citizen before that person's constitutional right is infringed? My question is, how about the First Amendment? How about we not let them set up a website or a Google account? How about we not let them join the church until they can petition the government to get off the list? How about not get a lawyer? How about the Sixth Amendment? How about you can't get a lawyer until you petition the government to get off the list? Or my favorite, how about the Eighth Amendment? We're going to subject you to cruel and unusual punishment until you petition the government to get off the list. Is there another constitutional right that we treat the same way for American citizens that we do the Second Amendment? Can you think of one? Can you think of one? And it is my opinion that Senator Godey, particularly when he said, or my favorite, how about the Eighth Amendment? We are going to subject you to cruel and unusual punishment until you get off that list. Don't tell me he didn't know about the cruel and unusual punishment that it's being perpetrated on Americans.
Those are the words. Thank you for reading it. You did an excellent job.
Thank you.
That concludes our review of the petition to the Supreme Court. I want to emphasize to our viewers that this is the first time in history that the victims of the targeting program, or what we call targeted or listed individuals listed in handling codes 3 and 4 of TSDB. We are knocking on the Supreme Court of the United States door for the first time in history. Remember this moment. This is the beginning of our liberation. And Anna, congratulations on this monumental achievement. This is truly, truly historic. You're making history. Targeted justice is making history. We all targeted individuals are part of this history. So whether you're optimistic or pessimistic, this is the first time that it ever happened. Tell me, what else can we do to make the Supreme Court justices pay attention to this particular case?
Well, the first thing, as you all know, we have planned a targeted action event in Colorado Springs from the 28th to the 30th of August. And if you can make it there, do not think twice about it, because the only way we are going to get the attention and we're going to, just put out there to the world that this is not fantastical, that this is not unreal, is with sheer numbers. We need for every targeted individual that can make it there. I know that a lot of people have financial constraints, but if you can make it there, this is your opportunity to have your voice heard. We need for America to see the suffering that we are real, that the targeted community is real. And I just have to comment something that on the past weeks and months, government criminals that run this on a knowledge access program have been not only increased the torture on people, but also have been doing everything they can to discredit targeted justice and its efforts. If you fall into that trap, you are doing work for them. Do not listen to these criminals. Do not listen to your V2K, but because what they want is for you to work for them. And by trying to minimize, by trying to disrupt and divide, that is my urgent plea, because we are working for everybody's freedom. And when you attack any of us that are giving our lives for this, you are attacking yourself.
That's
What
very
I
well
had to
said.
say.
I completely agree with it, with this sentiment. I also want to acknowledge that this process going to the Supreme Court, and we will be reaching out to organization to provide amicus briefs in support of our cases. I mean, all this process, not only it takes a human toll on people doing this, it's an extraordinary financial burden. And for a nonprofit organization that is basically supported by your donations, it's an extraordinary task to accomplish. So we urge you, please don't forget to support us. Be an activist, subscribe to the Substack newsletter, make a donation. This is the critical moment when we truly need your support. Please understand, this is the moment of history that everybody will remember. This is the first time targeted individuals are knocking on the squatter's door. Excuse me, my metaphor, but that's what I'm gonna call this podcast. It's been wonderful, Anna. I think we covered a lot of topics. Would you like to say goodbye to the audience?
Yeah, I want to thank everybody for your support and your kind words. I get messages from so many people that they really touch my heart, and they really inspire me to continue going, like the Energizer Bunny, even when I feel my energies have been depleted. This has been a very difficult endeavor, and most importantly, because I have such a huge responsibility to all of you. And I don't want to do a bad job. It's such a huge responsibility to do the best of my abilities. So I certainly tried that, and I certainly hope it renders fruit. I am convinced that God is on our side, and let's just wait. It's going to take a little while for the court to first, like I said in the beginning, determine that the brief is compliant and docketed, and then to decide if they're going to issue the cert, and then what comes later. So we really need prayer warriors on this, because prayer is very, very powerful.
Well, I really don't have anything to add. I think we accomplished the task that we wanted to accomplish. We gave you these breaking news and a very detailed breakdown of the petition to the Supreme Court. Looking forward to your comments. Looking forward to your support. Until next time.